Hello and welcome. My name is Jason Castillo. I'm the Director of Legal Education with Attorney Credits. The purpose of this micro-seminar today is to run through some of the ethics of attorney websites, something that's near and dear to your heart as it is mine. So let's jump right into things since our time is brief together. First of all, the regulation that you face in regards to your online advertising comes from the national and state level. At the national level, we have the ABA Rules of Model Conduct. Model Rules 7.1 through 7.5 are controlling. These rules deal with everything from specializations to domain names, communications and advertisements. Also at the national level, one of our main cases is Bates versus Arizona, actually the main case, decided in 1977. Prior to this case, legal advertising was impermissible. So we've had only a little over 30 years to usher in legal advertising. And over the last 10 years or so, this has begun to manifest in our online environment as well. At the state level, which is what you should really be concerned about because the states interpret the Bates decision through their ethics codes and ethics opinions, and the rules of your state are going to be controlling. But again, in the online environment, there aren't always rules in your jurisdiction, so you have to be aware of the national and other state environments. Because what happens in California or New York today could be happening in your state tomorrow. And if you are prepared for this, you're going to be much better off before you get that call from the state bar. So a few areas that attorneys get themselves into trouble would be the content on the website. A second main area would be domain names. Also, another issue you have to be worried about is the unauthorized practice of law, in addition to the formation of the attorney-client privilege. And then lastly, kind of a catch-all category, what you post on your site, other people's sites, newsletters, and third-party websites have also gotten a number of attorneys into trouble. So let's start at the beginning with domain names. Obviously, domain name, Greg Victorov would kill me if you heard this, but domain name almost acts like a mark nowadays. I know that it is an online address, but in today's times, that online mark, that domain name, that URL, that's what people are looking for when they buy their goods and services, obviously. So the problem that we've come across in our new online environment is what if a law firm or an attorney doesn't wish to have the same firm or name as the domain name. For example, you might want to call yourself CaliforniaInjuryAttorney.com. Is this permissible? In many states, New York and New Jersey to mention a few of them, this is permissible. As long as the Bates standard goes, the domain name is somehow not misleading or untruthful, then using a domain name that doesn't match the firm or attorney's name is permissible. And this was a New York Formal Opinion 2003-01. The court went on to list a few other domain names that would be considered misleading, like bigverdict.com, bigjudgment.com, bestlawyer.com, greatattorney.com, personalinjury.com. The New York courts opined that this would be misleading because of the name implies when you're advertising bestverdict.com, that's almost like a guarantee or a warranty to the potential legal consumer. A few other states that have also harnessed the same standard are Arizona and Ohio. The second and main area that really gets attorneys into trouble is the content that they post on their website. And again, falling back on Bates, the content must be truthful, not misleading. So what if you wanted to go ahead and post a picture of yourself and a judge? And you can imagine a scenario where you partook in maybe a charity golf tournament for the local bar association, and there you are, three partners of the firm standing arm in arm on the 18th green with a local judge. And you prominently display that on your website because you think it makes you look great. Well, this can get you into trouble. In a state like New Jersey, if the purpose is for that judge or that picture looks like they're advertising or marketing the firm's services, that is impermissible because it is misleading. In addition to maybe pictures of judges or other items, make sure that the information on your website is current. There was a New Hampshire case a few years ago where an attorney who went solo sued his old firm 6 months after he left the firm because the firm continued to display his old information. And again, this makes it misleading or untruthful because the attorney no longer worked at the firm. And it eventually took a lawsuit and 1 year for an attorney to do about 10 or 15 minutes of programming work and taking that person's name off their site. Pretty easy to do if you have the right people in hand. Another issue that gets people into trouble is listing specializations. Again, don't say that you're a tax specialist or a tax expert unless you're licensed through your state board. That's gotten many people in trouble. As I know in California, you have to do a certain amount of hours to be considered a tax specialist, and the same holds true for many different states. Again, it's best to know the rules of your states. In this 5-minute micro seminar, I'm just giving you some points to consider. Lastly, and what really gets people in trouble under the misleading category are guarantees, warranties, monikers, and testimonials. And something innocuous as posting past case results would fall into this category. And that's something that almost a lot of websites do, and in some very stringent states that really interpret their advertising codes draconianly, you can't even list your past cases, because for a potential legal consumer, that's a misleading guarantee or warranty. If a person comes across your website, sees the past cases, they're going to equate that with future success. So be very careful about the names you call yourself, what you say on your website, especially in different states, because a state like New York has some pretty stringent advertising rules, while a state like Florida is a bit more lax. And then there's a state like California that really has no regulation in the electronic domain, so it's kind of a free-for-all to a certain extent. And many times courts and regulators will fall back on traditional guidelines for radio and TV, which have absolutely no place in our new online environment. Third area that really gets people into trouble would be the electronic formation of the attorney-client relationship. And where a lot of law firms get themselves into trouble is they list all kinds of email submission templates, numerous ways for potential legal consumers to communicate and send confidential information to the law firm or attorney. And this is addressed in California Formal Opinion 2001-155, which dealt with a divorce case. And this led to a 2005 decision from the Ninth Circuit, Barton versus U.S. District Court for the Central District of California, in which the Ninth Circuit analyzed disclaimers on law firm websites, because that's what a lot of these cases hinge on, is the language that disclaims forming this relationship. And where many times law firms will seek to employ language that is boilerplate, legalese, and goes way too far, stripping rights that can't be stripped from legal consumers, courts have opted for a plain English approach. And instead of saying that this information is going to be used offensively against the client, the language of Model Rule 1.18 is much more instructive, and that details that the receipt of information will not preclude the law firm from representing other parties in the matter. So again, softer language, instead of being harsh and being used offensively against the client, it's used a little bit lighter. So again, be careful with the disclaimers that you have on your website, because that can get many firms into trouble as well. Lastly, or the last main area that we're going to cover in this micro seminar, because our time is brief, is going to be the unauthorized practice of law. Again, a website is not like TV or radio. It knows no geographic boundaries. If I have a website advertising my legal services in California, I can't just go turning that off in a state like New York. So be careful. And there's also, again, California Formal Opinion 2001-155. They list about 4 or 5 things that you might want to place on your website as far as content goes, which will disclaim this relationship or disclaim this practice of law in other jurisdictions. And it's always a good idea to list the partners at your firm, your practice, the areas that you take. These are always good things to have listed on your website. And then lastly, just a catch-all category. If you have newsletters, brochures, something like that on your site, make sure that you're not practicing law. And again, this is a very good area for a disclaimer. And then lastly, appearing on third-party websites is also a dangerous area and has gotten a number of attorneys in trouble. For example, maybe you're a real estate lawyer, you want to be listed with like a real estate firm on their site as, their lawyer. That would probably definitely get you in trouble. But again, it's best to know the rules of your state and cases decided in your jurisdiction. My name is Jason Castillo. I am the Director of Legal Education with Attorney Credits. We have some great courses online on our website if you do care for more information, or please feel free to email me at jcastillo.com, or you can also find us on Facebook or check out our blog as well. Thank you very much. I look forward to your comments and hearing from you.